Every day in the USA, people find themselves in court.
We're about to do a preliminary examination in the matter of People versus Dale Carson Odell Dieter. That's you, sir?
Yes.
Mr. Dieter, you're charged with several things. You're charged in count one with possession of methamphetamine as a second or subsequent offense. That is a felony punishable by up to 20 years imprisonment. Count two, you're charged with child abuse in the second degree. You did knowingly or intentionally commit an act which was cruel to a child by putting zip ties around the throat and wrists of this child and assaulting them. That's a felony punishable by up to 10 years imprisonment. Count three is assault with intent to do great bodily harm less than murder by strangulation. Same complaining witness. That's a felony punishable by up to 10 years imprisonment and a fine of up to $5,000. Count four is domestic assault or domestic violence as a third or subsequent offense, which is a felony punishable by up to 5 years and a fine of up to $5,000. Could be consecutive to other charges, and you're charged as a fourth habitual offender, theoretically making this punishable by up to life imprisonment. You're here with your lawyer, Mr. John Bush. Also present is Chief Assistant Prosecuting Attorney Joshua Robert and the deputy in charge of this matter, Mr. Travis Miller. This is the time and date Mr. Dieter set for a preliminary examination on these charges. I think I told you at the pre-exam, but I'll repeat it here. A preliminary examination is a hearing that's held to determine whether the prosecutor can establish probable cause to believe that a crime was committed and probable cause that you did it. You won't be found guilty or not guilty at this proceeding. It's just a hearing to determine whether there's enough probable cause to transfer the matter to circuit court for further proceedings, including trial. That's called binding the matter over to circuit court. When we discussed the matter a few weeks ago at the pre-exam conference, and again here just this afternoon, your attorney indicates you wish to have a preliminary examination and do not wish to waive that right here this afternoon. Is that correct?
Yes.
Mr. O'Bear, are the people ready to proceed?
Yes, Your Honor. A couple of preliminary things. We had made an offer on this case. He had until the end of the day last Tuesday to consider whether he wanted that offer to be held open by waiving his preliminary exam. I did not hear anything from his attorney, so I assume that he fully understands that that offer is revoked. And because this is a case involving a child victim, after a preliminary exam, no further offers will be made. Additionally, because it is a child victim, we would ask that that portion of the preliminary exam not be broadcast on Zoom to protect that child.
I certainly agree with that. What was the offer?
So the offer was to plead to possession of meth and child abuse second degree. The other charges would be dismissed and the fourth habitual would be reduced to a third habitual.
And you considered that offer, Mr. Dieter, and you declined to accept that?
Yes.
All right, which means, and that's the way I did it when I was prosecutor. If you made the child testify, I revoked all plea offers and there was no other discussion, which is probably why I tried 40 child CSC cases. All right. Our first witness will be the complaining witness.
Yes, Your Honor.
Now, you also mentioned you may have to ask to continue the matter.
Yes, Your Honor. So we subpoenaed a doctor who did a medical exam with the child. That subpoena was served. That witness has not appeared today. Additionally, because of an error by me, one of the officers who would be an important witness for the methamphetamine charge was not subpoenaed.
Was the doctor personally served?
Yes. It's my understanding. We have a subpoena returned signed by one of the deputies from the sheriff's department.
Well, he's not in our Zoom feed. We can discuss where is that doctor?
I believe out of Bronson. No, it's the Three Rivers doctor. It's from Beacon Health.
All right. Well, we're going to suspend the live stream, which we always do when there are child witnesses. We may resume after that to close things out, but it looks like we're going to have to continue this for further testimony regardless. All right, we return to the preliminary examination in the matter of People versus Dale Carson, Odell Dieter. We've completed testimony of one witness. We are back with our live stream. Next testifies Deputy Travis Miller. Deputy Miller, will you stand up so I can swear you in?
Yes, sir.
Thank you. Mr. O'Bear,
Where are you employed?
The St. Joseph County Sheriff's Office.
And you're talking kind of quiet. Can you speak up or move closer to the microphone?
The St. Joseph County Sheriff's Office.
How long have you been employed there?
Almost 3 years.
Want to turn your attention to an incident that was reported back on October 12th of 2023. Do you remember working that night,
Yes.
that day? Do you have a dispatch involving possible child abuse?
Yes.
When was that at?
I believe it came in right at the beginning of shift. It was the first complaint I handled that day
And when did your shift begin?
at 1800 hours.
So that would be about 6 o'clock
Correct.
at night.
Yes.
Where were you dispatched to?
It's a address on Molly Landing. I don't know the 5-digit address off the top of my head.
And would that be 27061 Molly Landing Road?
That sounds correct. I believe it's the second resident. It's west of North Centerville Road, or check it, east of North Centerville Road on the south side of the road.
And is that located in Sherman Township, St. Joseph County, Michigan?
Yes.
Can you tell us what happened when you arrived on scene?
I arrived on scene with the CPS worker who was going to do a child removal. She kind of briefed me on the situation that she was dealing with. And at that point, I was just doing a peace officer standby until I received her investigative report to do my investigation.
Do you have contact with Dale Dieter at the scene?
Yes.
And do you see him here in the courtroom today?
Yes.
Could you point him out and identify what he's wearing?
He's wearing a black and red collared shirt button up with his name Dale on it. I'm not sure what the logo is. Also wearing black pants and boots.
Your Honor, will you let the record reflect that the witness has identified the defendant?
it may, not often the defendant has their name badge on, but yes, may I show that this witness identified the defendant.
Did you also have contact with Cameron Dieter?
I did not speak with him, but I was present while he was in my vicinity, yes.
And were you around when some pictures were taken of him?
Yes.
Your Honor, permission to approach the witness?
Yes,
We'll do the full body one first and then the next one. Deputy Miller, I handed you 2 pictures. Do you recognize those?
Yes.
Can you describe, let's start with the one that's more of a full body or kind of chest up. Who's in that picture?
That is Cameron Dieter.
And can you describe what you see in that picture?
I see a,
now we'll call this plaintiff's exhibit number 1.
Yeah, I was gonna move to admit it after he testified to it, but I would
Could you
move.
do 2 stickers of plaintiff's 1 and plaintiff's 2? Go ahead.
I see a juvenile male who has bruising around his eyes, a slight bruise and a thin line around his neck, and some other red marks on his face.
And is that a fair and accurate representation of how he looked on that date when you saw him?
Yes.
Your Honor, I'd move to have this picture admitted as exhibit 1.
No objection. Plaintiff's exhibit number 1 is received.
Can you describe what you see in that second picture that I've handed you?
Yes, it looks like Cameron Dieter's neck with some thin line bruising
And that is Cameron Dieter.
Yes,
So it's just a closer up version of that other picture. He's pulling down his collar a little bit to better show off the injury around his neck.
yes,
And is that a fair and accurate representation of how he looked that day when that picture was taken?
yes.
All right, Your Honor, I'd move to have this picture admitted as Exhibit 2.
Did you take these?
No, the CPS worker, Darcy Borden, did.
But you were there when it was taken.
Correct.
Maybe you can clarify what time they were taken?
Yes, go ahead.
I don't have the exact time, but it was within the hour after we arrived on scene.
Appears to be some daylight in the background, unless it's lighting. I guess that's why I'm asking you.
Yeah, it was still the beginning of fall, so the sunset wasn't until about probably 8 o'clock, between 8 and 9 o'clock that day.
I'm going to publish exhibit number 2.
So again, by your recollection, it was probably in the first hour of you being on the scene?
Yeah,
Thank you.
Thank you. Exhibit 2 is also admitted if I didn't say that.
Deputy Miller, when you were there, you didn't interview the child, correct?
correct.
And did you interview Mr. Dieter?
I did not.
As part of your investigation, did you receive a baggie of methamphetamine?
I believe one of the deputies took it as evidence.
All right. But you personally weren't involved in the collection of that evidence.
I don't recall me personally processing the evidence.
I have no further questions. Actually, I do. So can you describe the property that you were at?
Yeah, it was a single-story residence, manufactured house, and a long, full-length back porch. Not quite full length, by 3/4 length back porch. Had a sliding glass door that led into the living room. Had a kitchen in the middle section of the house, and then the bedrooms were on the northern end of the house. The house runs north-south.
And is this a trailer?
It's like a manufactured house. I wouldn't quite call it a trailer.
All right, and so the testimony earlier about a trailer park versus a different home, those were, to your understanding, 2 different places?
Correct. I believe they lived at Memory Lanes beforehand. Not exactly sure if that's the trailer park they lived at, but as described to me, it was a completely different residence, the trailer park compared to the lake house.
Thank you. I don't have any other questions.
What other officers were there with you?
Deputy Kevin J. Penn and Deputy Keenan Morrill.
Any other PS worker or just Ms. Borden?
It was just Miss Borden.
Thank you. Mr. Bush?
Yeah, but this is kind of a follow-up to the judge. We know that there were 2 other deputies and Ms. Borden there. What civilians were there?
There was a subject identified as Christopher Baker. He was outside of the residence on my arrival. He was taken into custody for a warrant. There was also another male subject identified as Channing. I can't recall his last name. Sounds like that's Crystal's cousin. And
An adult?
yes,
Go ahead. Thank you.
and then there's also Crystal's mother who arrived on scene with her. That was a short time after we had already been on scene. There was some other subjects that stayed out in the yard I didn't make contact with or identify. They weren't related to the incident.
And this should be an obvious question, but what lake was it on? Or near?
Oh,
That would be
the
Omina.
east side of Omina Lake.
Yes.
Did this property abut up to Amina Lake or was it set back?
Nope, it actually sits within the Molly Landing, does a loop and then dead ends and loops back around. It's in the inside loop. So it's not on the water.
And did you go inside the house? Or
Briefly,
in the trailer or whatever you want to call it?
I stepped in to make contact with a CPS worker to ask a question at one point, just into the kitchen.
Did it appear to be occupied?
Yes.
Thank you. No further questions.
Did you recover any other evidence? Cut zip ties or anything like that?
No, I did not observe any zip ties.
All right, maybe leave that for other questions.
I don't have any other questions.
All right, thank you. You can step down. We've established identity and venue. There are still, and maybe some elements of some of the offenses. Who do you have left to call as a witness?
Today, I don't have anyone left to call as a witness.
And you're going to ask to continue it?
Yes, Your Honor. Two witnesses in particular, Deputy Kevin Penn, and then the Dr. Joshua Vance.
All right, I'm going to continue this to Thursday, April 11th at 1:30. We expect to have two witnesses. We prefer in testimony to have the witnesses here live, but we do give some indulgence to medical witnesses. Mr. Bush, do you have any objection if we will
I
only
have no objection with
to
it.
do Dr.
For
Vance
purposes of prelim, if the doctor is done by Polycom. So
by video? I have lots of questions, but I'm going to have to wait until we hear further testimony. All right, this matter is continued for further hearing and testimony from a medical expert and perhaps further investigating officers on April 11th. Mr. Dieter, your bond is continued under all the same conditions. You're to be here at that time. Thank you. You're free to go. This is the time and date scheduled for a continued testimony taking in the matter of People versus Dale Carson Dieter. Mr. Dieter is here with his lawyer, Mr. John Bush. The original charges, to recap, were possession of methamphetamine, child abuse in the second degree, assault with intent to do great bodily harm, and domestic violence as a third offense. We took some testimony last week from the complaining witness, or one of them, and from Deputy Travis Miller. The matter was continued for further preliminary examination today. We have a witness in the queue. I'll bring them in. They're here on behalf of the prosecution. Mr. O'Bear, are people ready to proceed?
Yes, Your Honor.
Mr. Bush, are you ready as well?
sure.
We're taking testimony in a preliminary examination in the matter of People versus Dale Dieter. You've been subpoenaed by the county prosecutor to give testimony in this matter. If I understand correctly, you're a medical doctor who has given some medical care or treatment in this case. So let's begin once again I'll ask you to state your name. Would you state your name, please?
Yes, it's Joshua Vance.
Dr. Joshua Vance?
Yes, sir. Yep, Dr. Joshua Vance.
All right, Dr. Vance, Mr. Joshua Robert, Chief Assistant from the Prosecuting Attorney's Office, is going to begin the questioning.
Good afternoon, Dr. Vance. Where are you employed?
I'm employed at the Three Rivers Hospital in the emergency department.
And what's your position there?
I'm an emergency room physician.
And how long have you been an emergency room physician?
Since including residency, well, as an attending since 2010.
All right, I want to turn, I'm sorry, did I cut you off?
No,
Okay. I want to turn your attention back to October 12th of 2023. Did you see a patient named Cameron Dieter?
yes, sir.
All right. What can you tell us about seeing that patient?
After I can say that I saw this 9-year-old. I remember what I remember from the actual incident is that I saw a 9-year-old with his brother, and then there was a female in the room, and there was an alleged abuse, but I don't remember details other than that, except for what I wrote in my note. And
All
then
right.
I reviewed the note here in the past week or so.
All right. So when you you mentioned a note, when you see a patient as a emergency room physician, do you create a type of note or report about seeing them?
Yes,
And that kind of breaks down when you saw them and what you observed during that examination.
yes,
And you did that for this patient?
yes.
All right. Your Honor, I'd move, I don't know how to show it to him to make sure it's what we're talking about. Dr. Vance, we spoke earlier and I emailed you a copy of your report that had your signature on it. Is that what we're discussing?
Yes.
I'd move to have that admitted as, I don't remember where we left off after the pictures, but as an exhibit.
I think we took 2 pictures.
All right, so exhibit 3.
That's my recollection.
I have no objection for purposes
Yeah,
of
it'll be exhibit number 3. All right, you may inquire.
Did the court rule that was accepted as an exhibit? I'm sorry.
There was no objection from you, Mr. Bush, is that correct?
I said for personal.
Yes, for prelim purposes only, it is admitted.
Doctor, do you have a copy of that with you?
Yeah.
All right. On the second page of that, there's a section called eyes. And you noted that patient has petechia paraorbitally around both eyes and an abrasion over his nose. Can you explain what that means?
So petechiae are little tiny red dots, and that usually will occur if there's like increased pressure in the face. So like if you cough or sneeze, or if you vomit a lot, those sorts of things. So if there's increased pressure in the face.
All right, and you note on the first page that the chief complaint was strangulation. Is strangulation also something that causes that petechia?
It can, yes.
And further down on that second page in the section titled neck, you noted in your report, patient does have a very thin petechia-like red injury at the base of the neck. Anteriorly, no bruising or signs of injury post-orally. What does that mean? What did you observe?
Well, it was a mark around the base of the neck where something could, it would be caused by something that's causing pressure.
All right. Thank you, doctor. I don't have any other questions.
Mr. Bush?
Hello, doctor, can you hear me okay?
Yes, sir.
Thank you. The young boy that you talked to, were there any other injuries that you observed?
There were no other injuries except for I did note an abrasion over his nose.
I'm sorry, you abrasion over and I didn't catch the last word.
Abrasion over his nose.
Thank you. Okay.
No other injury other than those.
And as part of treating him in the emergency room, was a decision made to admit or not admit him to the hospital?
The patient was not admitted.
Did you prescribe any medication or treatment or therapies when he was discharged from the emergency room?
No, I didn't prescribe any medication.
How long would you say you observed and examined him, doctor?
He did not stay in the department very long, maybe an hour.
And was this person able to communicate? I'm not asking what communicate about. Was he able to speak and communicate with you?
Yes, he was able to tell me what happened.
Was the young boy, was he complaining of any pain?
He had no neck pain and no headache and no other pain that I can see in my note. No pain.
Thank you, doctor. I have no further questions.
So far, we've identified this patient as a 9-year-old boy with nothing further. What was the name of the patient that you were treating?
Peter?
Your phone is cutting out. I'm not sure the record got that. Could you say that again?
Sure, sorry. Cameron Peter?
You mentioned that his brother was with him. How old did the brother seem to be?
The brother, I feel like was around the same age, or yeah, I would say the same age. I don't know if he was older or younger, but he was
Did you-
close to the same age.
Did you do any examination of the brother?
No, I did not.
It says in the report, I just got this, a diagnosis, well child exam, alleged strangulation, petechiae around the eyes and base of his neck anteriorly. Are those consistent with an allegation of strangulation?
They can be, yes.
All right. I don't want to get too in deeply if no one else is going to ask the questions. All right. Mr. O'Bear, anything further?
Doctor, you just said that fits with strangulation. And like the exhibit that has been admitted, your report says that is what Cameron Dieter told you happened, that he was strangled by zip ties.
Yeah, it says, yeah, he was. It says in my note that there was a zip tie around his neck.
All right, and after that, he said he might have passed out. Is that correct?
That's correct.
Thank you. I don't have any additional questions.
Thank you, Mr. Bush. Anything further? Dr. Vance, just for the record, where are you right now?
I'm in Grand Rapids, sir.
And I guess I'll do one more thing, Your Honor.
Yes.
Doctor, with our police report, it looks like we have similar notes from you for that same date, looking at the two siblings that came in. Is it possible that you just don't remember examining the two siblings that were with the child you testified to?
Yeah, I mean, that would be very likely because unfortunately, I don't remember the patients that I see a lot often. In fact, this one, I could only vaguely remember until I read my note. I remembered a little bit more.
All right. Thank you, doctor.
All right. Thank you, doctor. You're free to go. Thank you. Mr. O'Bear.
Thank you. I called Deputy Kevin Penn.
Good afternoon, sir. Raise your right hand, please. State your name.
Kevin Penn,
Thank you. Please have a seat.
Will you please state your name and spell your last name for the record?
Kevin Penn, Penn,
Where are you employed?
St. Joseph County Sheriff's Department,
How long have you been employed there?
a little over 6 years.
What do you do at the sheriff's department?
I'm a deputy for the road patrol.
And were you working December 12th of 2023?
What was it, October 12th,
Oh.
2023,
That was a test.
right?
You passed.
Were you working October 12th of 2023?
It was.
All right. And did you have contact with Dale Dieter on that date?
Did,
Do you see Dale Dieter here in the courtroom?
I do.
Can you point him out and state what he's wearing?
Black shirt says Big Buck on it.
Will the record reflect the witness has identified the defendant?
It may.
Where did that contact occur?
On Melee Landing, I believe it's 27061.
And that's Sherman Township, St. Joseph County, Michigan.
Correct.
What led to your contact with him?
We were dispatched there to assist CPS with a child abuse allegation.
And why specifically did you have contact with the defendant?
I was assisting Deputy Miller, who was handling the original. I arrested Mr. Dieter on an unrelated warrant.
Was there a discovery of methamphetamine as you were with Mr. Dieter?
There was, when I was
Can you explain the circumstances that led to that?
when I was securing another subject for a warrant, Mr. Dieter had requested that I have Channing get his cigarettes so that his children would not get a hold of them. On my way back down to the house, I spoke with Betty, who is my understanding the grandmother of the children in question for the child abuse allegation. I advised her of the request from Dale Dieter to get the cigarettes. Later, I was at the residence approximately 10 minutes afterwards, and Crystal was sitting on the porch.
And who's Crystal?
To my understanding, she is the mother of the children of the alleged child abuse allegations. She was sitting there holding a red and white box of cigarettes. She looked into the box and pulled out a plastic baggie with what appeared to be methamphetamine. She asked Channing what this was, and Channing said they were Dale's cigarettes and that it looked like a baggie.
Yeah, I guess we didn't hear some, and I wouldn't object to that.
Yeah, we've got a couple layers, but so did you see this person pull the baggie out of the pack?
Yes, I was standing right in front of her.
Okay. There was a hearsay objection, and what I heard did appear to be hearsay.
And my response would be Michigan Rule of Evidence 1101 would apply during preliminary examinations. Under Part 8 of that rule, property hearsay testimony about ownership is allowed.
That is true. There's a specific exception for preliminary examinations. Mr. Dieter, I mentioned this last week, and your attorney did something earlier. He had allowed the admission of this exhibit for preliminary examination purposes only. We couldn't just put this into evidence in a jury trial without more. But the rules of the preliminary examination are less strenuous than they are for an actual trial. And there is a court rule, which Prosecutor Robert cited, which allows some hearsay to come in for preliminary examination purposes when it's regarding the identification of property. There are some other exceptions as well. But I will allow the testimony regarding statements that go to the ownership of this methamphetamine. So the objection is overruled.
So I believe you said Channing, is that?
Channing, correct, another male on scene, the one he had originally asked me to go tell to get the cigarettes. Betty was also there, and she mentioned that those were the cigarettes that she had got out of her, referring to Crystal's bedroom. My understanding, I'm not in charge of the case for the child abuse, but understanding that Crystal and Dale's bedroom would have been the same.
Did you speak to Dale about this?
I did. I read him his Miranda rights off a department issued card. He stated that he understood his rights and agreed to speak with me. Dale admitted to finding the baggie of suspected methamphetamine. He stated that he was going to flush it, but had just not gotten to do it yet. And then when police arrived on scene, he shoved it in his cigarette box.
All right, so he admitted to you that he had possession of that was his cigarette box and he put the methamphetamine in there?
Correct.
Was that methamphetamine sent to the Michigan State Police Crime Lab?
It was
And what were the results of that testing?
Schedule 2 methamphetamine.
Did you have any further contact with Dale Dieter about that?
Not that I recall at this
And
time.
did you have any further part in the investigation into the child abuse in this case?
No.
All right. Thank you. I don't have any other questions.
How much was it?
I believe it was 0.59 grams according to the lab results.
And it was in just a cellophane baggie?
Clear plastic bag to the best of my recollection, yes.
Anything further, Mr. O'Bear?
No, nothing further.
Mr. Bush?
Deputy, was it a full plastic bag, or sometimes you see plastic bags cut off in a corner? Do you remember?
I did not process the evidence afterwards. I collected the evidence from Crystal, and it was turned over to Deputy Miller for processing. I didn't do the photographing of it or anything like that.
When you first saw it, was it in the cigarette package?
When I first saw it, I was standing in front of Crystal, who was sitting on the porch. She pulled it out in front of me and seemed surprised that there was a plastic bag of methamphetamine in the box she was holding.
And so I get this, she had left to go find the cigarette box, then was,
Dale Dieter had asked me to have the cigarette box taken by Channing. I had made contact with Betty and informed her of Dale's request. When I went down to the porch, Crystal was holding a white and red cigarette box that was later identified to be the one that he had requested them to get.
didn't he ever tell you why he wanted somebody to get the cigarette box?
He said so that his kids would not get a hold of it.
No statement what was in it or not in it then? Or-
Not that I recall. He just told me he didn't want the kids to get the cigarette box, something along those lines.
And you thought that was reasonable, so you went ahead and let the person do that then? Or-
Yes, he was in custody for a warrant at that time.
And where did you Mirandize him?
I believe that would be in the back of my cruiser, but I have to check my video to be 100% sure.
It could have been back at the sheriff's department, or it was on the scene
I
somewhere.
believe it was on scene in the back of my cruiser. I don't remember if I had him step out or not. It was after his arrest.
And that would be audio and video recorded then?
It should be, yes.
His response was he found that?
He found it in a trailer, I believe is what he told me. I believe he was referring to a camper trailer that was outside the residence that was destroyed. I don't know what they were renovating or what they were doing. I don't recall.
Did he give you indication when he found it?
Not that I recall. It's not noted in our report that there was a certain time frame he located according to that.
Did he give you indication of what the source may have been of the methamphetamine if he found it?
Not that I recall at this time.
Did he say in so many words that it was methamphetamine, or did he say it was a package of an unknown substance that he located?
I would have to review my video to make sure he said methamphetamine, but he advised that he located the object we had found. I don't remember if he said baggie or methamphetamine on that date.
Thank you. No further questions.
Any further?
Yeah, I would just move to admit a copy of the lab report.
Okay, I didn't know. That's why I asked. This would be exhibit 4. Once again, Mr. Dieter, laboratory reports are admissible under the court rule for preliminary examination purposes. And Deputy Penn's testimony matches what is in it. It was one Ziploc bag containing white material, 0.59 gram. I think that's packaging and all.
Yeah, let me ask a further question.
Certainly. Thank you. Exhibit 4 is received.
Deputy, was there another individual that was also taken into custody?
There was
And do you recall who that was?
Christopher Baker.
And was Mr. Baker, Mr. Dieter both put in the same vehicle?
I believe I transported them both, correct?
And do you recall, did you ever hear any words spoken by Mr. Baker about how the alleged or what was tested to be methamphetamine was located or where it came from?
Not that I recall at this time.
But if it was spoken, it would probably be on your audio visual.
Should be, yes.
After the defendant was Mirandized, did you ask him any questions about the incident with the child?
No, I was not handling that part of the investigation. That was being handled by Deputy Miller and CPS. I don't recall asking any questions reference to the children.
Did you ever go in the house?
Don't believe that I did. I believe I stayed on the front porch.
Did
My bad.
anyone ever go in and look for cut zip ties or a screwdriver or drill or anything?
I don't know. I transported the subject to the jail where it's the warrants.
When you first got there, did you realize there was an open warrant for Mr. Dieter's arrest?
Prior to arrival on scene, dispatch had advised us there was a warrant for subject's arrest, who was later identified as Dale Dieter.
So he was gonna go with you regardless.
Correct.
Okay, does that raise questions for anyone else?
No, Your Honor.
Thank you, Deputy. You can step down.
Thank you.
Stop at the podium there for just a moment. You did testify that somebody else processed and packaged this. What other officer was involved with that? Do you recall?
I turned the property over to Deputy Miller for processing.
Okay. Thank you. You're good to go.
Thank you.
All right, Mr. O'Bear, anything further?
No further witnesses.
Mr. Bush, anything further?
Defense would yes, Your Honor.
All right. I did review my notes. Let's recap the counts here. Most recently, we took testimony regarding count 1, possession of methamphetamine. There are 3 assault type charges: child abuse 2nd degree, assault with intent to make great bodily harm, and domestic violence with previous convictions. As a 3rd offense, making that a felony, subject to 4th habitual offender status. Mr. O'Bear, you wish to make your argument regarding the bind over?
Yes, Your Honor.
Thank you.
Your Honor, I would argue that based on the testimony given over the 2 days of preliminary examination, that the court should bind over this case on all counts. Today, we heard testimony about the methamphetamine that was found. It's been sent to the lab and confirmed to be methamphetamine. The defendant was Mirandized and asked about that. He admitted that he found it, he had it in his possession, he put it in his cigarette container. So I believe that is sufficient evidence to bind over on that count. Count 2 is the child abuse 2nd degree. For that count, did knowingly or intentionally commit an act that was cruel to a child by putting zip ties around the throat and wrist of the child and assaulting him. Looking at the jury instructions for that, cruel means brutal, inhumane, sadistic, or that which torments regardless of whether harm results. I think based on the testimony from the victim in this case, which the court heard, that it would fit the elements of child abuse 2nd degree. He testified about what happened to him, the zip ties, that he was left there as his dad and brother went to hide. The testimony from him is that they were both involved in that, and that it wasn't until he was found by a family member and cut out that he was able to get free. I think that easily meets the definition of cruel in the actions. As a tag along to that, although it's not on the original complaint, there's a charge for child abuse 2nd degree committed in the presence of another child. As the testimony was given, it's clear that the victim's brother was also there through this entire situation, another young child. So the elements are the same, except for that the other child was also there for that. And I think that's shown as well. The assault by strangulation, we have the testimony of the child again, who explains what happened to him, but we also have the testimony from the medical professional. We have that exhibit admitted, showing what the victim said at that time, so that there were the marks around the throat and what was observed in the eye, which indicate strangulation. And of course, the domestic violence would tag along with all of that. Additional exhibits were admitted showing the pictures of the child, which support his statements. The court can see the injuries for themselves, the mark along the neck, the injuries to and bruising on the face, which support what this child testified to here in the courtroom. So based on all of that, I would ask the court to bind over.
Thank you. Mr. Bush?
On behalf of Mr. Jeter, I would object to the bind over. I would ask the court to review the testimony exhibits in light of the standard of the state of Michigan. Point out just a couple of things. It's unclear how much knowledge Mr. Dieter may have had regarding what was in the baggie that apparently later was tested to be methamphetamine. You certainly don't accidentally possess something if it was located and found. I think a fair statement can be made that he did not know what was in that package. Regarding the assaultive portion, as has been noted, we don't know a whole lot about the zip ties, the drill tools, or whatever that may have been used in securing the young boy to the floor. I would ask the court to review the testimony and to dismiss those charges.
Anything further, Mr. Robert?
Sure. When it comes to the methamphetamine, the court's also able to consider that circumstantial evidence, his statements that he didn't want it around his kids, the statements
That he was going to flush it.
yes. So court already is pointing out that they've recognized that. So that's what I would ask the court to consider as well.
And Mr. Dieter, once again, this is all a probable cause standard. You're not being found guilty or not guilty. There's just a finding that the prosecutor wants me to make, that there is probable cause to believe these crimes were committed and probable cause that you did it. Probable cause is a much lower standard than proof beyond a reasonable doubt, which is the standard required at a trial. So we're just establishing probable cause. So the first one is easy for the very reasons Mr. Robert just spoke to. This was more of a constructive possession of methamphetamine, but you wanted to get the cigarette pack out of there, which was a good plan. Then somebody pulls, they wouldn't have given you the cigarettes and had you smoke one on the drive back to the sheriff's department. I'm not sure what they were going to do with it, but they got it out of there. And then the methamphetamine was exposed. Now we understand why you didn't want it around the kids. You acknowledged that you knew it was there and you were going to get rid of it. Whether that's true or not, I don't know, but nonetheless, that's a sufficient constructive possession for bind over on count 1, possession of methamphetamine. Child abuse in the 2nd degree, count 2, did knowingly or intentionally commit an act that was cruel to a child by putting zip ties around the throat and wrists of this child and assaulting him. And that's what the testimony was. And Mr. Robert quotes from the jury instructions, which give a closer definition of what cruel is. But I've been trying to get my head around this since I first heard Cameron's testimony last week. He was very earnest. He was trying to tell the truth as best as he could in the court's assessment. Why this would happen, you and your other son, who's slightly younger than Cameron, put zip ties around his neck, his wrists, his feet, and using a battery-powered drill, fastened him to the floor, and then hid in the closet I don't know if it was supposed to be some joke that was not funny, that when your wife came home from work, she'd find him there in the middle of the floor. I don't know. But to take this child and screw him to the floor, which was frightening to him. He has marks around his neck, ligatures from the zip ties. He said he couldn't breathe, and he has petechiae in his eyes. The doctor was not very powerful testimony on this point, but generally, petechiae are an indication of strangulation or loss of oxygen. And in the struggle, blood vessels burst in your eyeballs and cause these red marks. I've heard lots of testimony over the years about petechiae, and I used to prosecute these cases. Anyway, there's certainly sufficient probable cause to believe that there was child abuse in the second degree. And that we would add a third count that this was done in the presence of another child who was actually a participant in this incident. His brother and father were fastening him to the floor. And so a third count can be added. Count 4 becomes assault with intent to commit great bodily harm by strangulation, which is the same level of punishment as child abuse in the second degree. Again, it's probable cause. He has a zip tie, and for reasons I don't understand, nobody went in the house, took pictures of anything, looked for the zip ties, looked for the drill. You know, he did this, I did this. So maybe there's more evidence that I haven't heard. I'd hope to hear something about what was found inside the house. But I don't know that anybody even looked for it. But nonetheless, I believe there's also probable cause to believe that there was strangulation, and that supports that count 3, which now becomes count 4. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It's having an impermissible touching or a battery against someone who's a member of your same household. There's certainly probable cause to believe that. But it becomes a felony when there's an allegation that there's at least 2 previous domestic assault convictions. And the prosecutor has listed 2 prior convictions, which would support the bind over. One is in 2016 and one is in 2014. So I'm going to bind the matter over on all the counts requested. There's a new count 3. Count 3 becomes count 4. Count 4 becomes count 5. You have posted a substantial bond. You've been at every proceeding. And although I didn't like what I heard, I didn't find enough to cancel this bond. My heart broke. Your son walked in there and said, "Hi, Dad." I was like, "Oh, yes, that's all right. It'll go away." So I don't even know what else to say about this. Matters bound over on all counts. The bond, which is substantial, I think there's pretrial services in here as well, has been posted. That bond is continued. Mr. O'Barrett asked you to file an amended information with that extra count. Mr. Dieter, the matter will be bound over to circuit court for further proceedings. The next stage would be a status conference. I think there are some other things going on in the family court as well. And there are conditions that you not have any contact with the complaining witness. All right. This record is completed.